Legal framework governing life insurance. Life insurance agents have an essential role in the insurance market, and they need to be familiar with the legal aspects of insurance. This includes understanding insurance products and their specific features, the general form and content of insurance contracts, and limitations on who can enter into valid insurance contracts. This chapter provides an overview of the legal framework for insurance to guide agents in their professional practice. Although agents are not expected to be legal experts, they can benefit from being aware of the legal framework and technicalities that regulate the insurance industry and their professional conduct. In Canada, insurance law is derived from several sources: the Canadian Constitution, common law, and legislation and regulation. The Canadian Constitution takes precedence over all other laws, including federal, provincial, and territorial legislation. It regulates the division of legislative powers between the federal and provincial governments under the Constitution Act, 1867. The Constitution gives both federal and provincial governments the authority to pass laws in their respective areas of jurisdiction. Insurance law is considered an exclusive provincial matter under the Canadian Constitution. Common law, which originated in England, is developed by court decisions and applies everywhere in Canada except Quebec, which uses a civil law system based on the Civil Code of Quebec. When a statute is passed, it can change elements of pre-existing common law to avoid inconsistencies. While principles of contracts, civil fault, property, and agency are still primarily governed by common law in Canada, insurance law has been mostly enacted through legislation passed by provincial and territorial legislatures. This chapter will provide an overview of the most important common law rules, statutes, and regulations relevant to life and health insurance agents. Life and accident and sickness insurance in its legal context. An insurance contract is an undertaking by one person to indemnify another person against loss or liability for loss related to a specific risk, or to pay a sum of money upon a certain event. This definition includes life insurance and annuity contracts issued by insurers, which are considered life insurance contracts under provincial and territorial legislation. Life insurance covers the risk of one or more people dying. Accident and sickness insurance may cover various health-related losses, including loss of the ability to work due to accident or sickness, disability insurance, the onset of a diagnosed illness like cancer or a heart attack, critical illness, accidental death or dismemberment, reimbursement of medical fees and drugs, and long-term care needs. Insurers. Insurance contracts are created and underwritten by business or mutual insurance corporations that are licensed by the government to act as insurers. Agency relationship. In law, a relationship of delegated authority is called agency, and the individuals in that role are called agents. The person or corporation delegating the authority is the principal who controls the extent of that delegation. Agents. In common law provinces and territories, the relationship between an insurance company and an agent who sells its policies is considered a principal-agent relationship. This means agents act on behalf of the insurance company when selling insurance to clients. The terms and limitations of an agent's authority are outlined in a written contract signed with each company they represent. Agents can be categorized as either independent or captive. Independent agents have contracts with two or more insurers and can sell policies from multiple companies. They often place their business through managing general agents, MGAs, who handle applications and commissions. Captive agents represent a single insurer or are bound by contractual agreements to represent a single MGA or insurance marketing entity. A captive agent might be an employee of an insurance company or an affiliate and only sells that company's products for a commission. They can also be a self-employed worker with a distribution agreement with a single insurer or its affiliate. Managing General Agent, MGA. A managing general agent MGA facilitates business between agents, their clients, and insurers by providing services such as assisting agents in obtaining contracts with insurers. Processing and tracking business submitted by agents, providing direct sales support. Facilitating the flow of information between the insurer and the agent. Pooling commission payments for agents from various insurers, facilitating the submission of contracts between an agent and an insurer. Training agents, providing market conduct, compliance support to insurers. Developing products or assisting with claims adjustment on behalf of an insurer. Agency. Insurance agency is a corporation or partnership that holds a license from one or more regulators. To hold a license for a specific category of insurance, an agency must have at least one licensed agent in that same category. An agent who wishes to expand their business by hiring, training, and supervising other agents must apply for a corporate agency life license that meets the requirements of the province or territory where they intend to operate. A corporate life insurance agency can also submit its business through MGAs. To become a licensed insurance agency, a corporate agency must meet specific conditions regarding nominees, trade names, and government registration. Any employee of an agency who acts as a life insurance agent must be licensed. This includes anyone who solicits insurance. Obtains an application for insurance. Negotiates or procures insurance, transmits insurance applications or policies, offers to negotiate insurance, negotiates insurance continuance or renewal, collects premiums, develops an illustration for life insurance. An insurance agency must be licensed in British Columbia, Alberta, Saskatchewan, Ontario, Nova Scotia, and Newfoundland and Labrador. Regulation of insurance and licensing. Because of the importance of insurance products, all companies selling life insurance in Canada, as well as their distribution channels and agents, are heavily regulated. Provincial and territorial insurance acts contain extensive provisions governing insurers. These laws grant designated actuaries extensive powers, including the responsibility to report on the financial soundness of a life insurer's business operations. Designated actuaries must be members of the Canadian Institute of Actuaries and adhere to its practices. Provincial and territorial laws also require insurance agents to be licensed. The regulatory framework and name of the applicable statutes vary by province. Nunavut's regulatory and statutory framework is the Insurance Act, RSNWT, New, 1988, c. I-4 under the Superintendent of Insurance of Nunavut, which is part of finance. General legal principles applicable to a life insurance agent. Although each province has its own legislation, all provinces and territories have based their insurance laws on a model statute created in the 1920s. This has resulted in very similar insurance legislation across Canada, except for Quebec. This uniformity is helpful for clients and insurers, as it provides consistent practices and procedures for life insurance contracts. If a policyholder moves to a new province after a policy is issued, the laws of that new province will apply to certain aspects of their estate planning, such as their will. However, the law that applies to the interpretation of an insurance contract, including beneficiary designations, will be the law of the province or territory where the policy was contracted. The consistent statutory basis for insurance contracts ensures consistent application of legal principles to an agent's business. The following legal principles from common law and statutory law are relevant to agents. Capacity and status of persons: natural persons, partnerships and legal persons, corporations, minors and guardians, powers of attorney, POA, marriage and common law unions, divorce and separation wills, estates and successions, trusts and trustees, bankruptcy. Capacity and status of persons. The law requires that anyone entering into a contract, regardless of age, must have the legal capacity to do so. Capacity refers to a person's ability to provide valid consent. In Ontario, a person aged 18 or older is presumed to be capable of entering into a contract, while someone aged 16 or older is presumed capable of giving or refusing consent for their personal care. Capacity means the individual can understand the contract's terms and that they are entering a binding agreement. Individuals who are mentally incapable lack the legal capacity to give valid consent and cannot enter into a contract, including an insurance contract. There is no maximum age for this presumption, so a 100-year-old person is still presumed to have the legal capacity to contract. Natural persons, partnerships, and legal persons, corporations. It is important to distinguish between a natural person, a partnership, and a legal person, corporation. Natural persons, individuals. A natural person is a human being. A natural person with legal capacity can make decisions about their person and property, and they have the right to enter into contracts. The term individual is also used in legislation, including for taxation, to describe a natural person. Partnerships. A partnership is an arrangement between two or more parties conducting business together for profit. The partners can be individuals or corporations. In an ordinary partnership, each partner can sign contracts for the partnership and is financially liable for contracts entered into by other partners. Some partnerships, like limited liability partnerships for lawyers and accountants, have a statutory limitation on partner liability. Legal person. Corporation. A corporation is a legal person, a separate entity from its owners and managers. Corporations have most of the property rights of individuals, allowing them to enter into contracts and own property. Business corporations are owned by shareholders, individuals, other corporations, or partnerships, and are governed by a board of directors. The board can delegate authority to officers, such as the president or vice president. When a corporation makes a contract, a signing officer must sign on its behalf. Insurance applications may require the signatures of two officers or directors. Minors and guardians. Minors, who are below the age of majority, do not have full legal autonomy. The age of majority varies by province and territory. It is 18 in Alberta, Manitoba, Ontario, Prince Edward Island, Quebec and Saskatchewan, and 19 in British Columbia, New Brunswick, Newfoundland and Labrador, Nova Scotia, Northwest Territories, Nunavut, and the Yukon. However, provincial insurance legislation states that a person aged 16 or older has the capacity to contract for an insurance policy on their own behalf, though not to receive death benefits as a beneficiary. Parents of minors under 16 have an insurable interest in their children and can apply for a life insurance policy in the child's name. In some provinces, parents also have the right as guardians to give consent for financial transactions on behalf of their minor child. Parents can appoint a guardian for their minor children in their will and authorize the executor to make payments to that guardian. A guardian may also be appointed by a court. Court-appointed guardians are important for insurance practice for two reasons. 1. They may be entitled to accept a death benefit payable to a minor and discharge the insurer from its obligation. 2. They may be the ones answering questions and giving consent for the release of medical information on behalf of a young minor who is the life insured on an application. If there is no one capable of giving a valid discharge for the insurance money, the insurer must pay the money into court within 30 days, to the credit of the minor. The money will then be managed by an official connected with the public trustee if there is no court-appointed guardian. Power of attorney, POA, and enduring power of attorney. Life insurance agents must understand the legal mechanisms for transferring rights to another person, such as through a power of attorney, POA. Adults can voluntarily appoint a legal representative to make decisions on their behalf for personal care or property management in case they become incapable. Power of attorney, POA, a legal document where one person, the principal, appoints another, the attorney, to deal with their business and property. A POA can be specific or broad, but it ends if the principal becomes mentally incapable. Enduring power of attorney. A legal document where the attorney's authority continues even if the principal becomes mentally incapable. To be valid, it must be properly signed and state that the authority continues despite the principal's incapacity. An enduring power of attorney for property may take effect immediately or only when a doctor or assessor determines the principal has become incapable. The attorney usually has all the powers to deal with the owner's property, but not to make a will. Most insurers will also refuse a beneficiary designation made by an attorney, with some exceptions, such as a court order or a transfer of an annuity with an existing designation. Before accepting instructions from a person acting as an attorney, an agent should obtain a certified true copy of the power of attorney and have it reviewed by the insurance company. Agents should generally decline to act as a client's attorney, executor, or trustee, as this is not covered by professional insurance and could lead to a conflict of interest or trouble with the regulator. If an adult becomes incapable without a personal representative, a court can appoint someone, like a trust company, to manage their affairs. Court-appointed guardians of an incapable adult can conduct insurance business, such as renewing a term policy or buying segregated funds, subject to the authority granted in the court order. Unlike an enduring power of attorney, guardianship only takes effect after a person is declared incapable. Guardianship also requires a proposed property management plan and is subject to court review. Clients sometimes mistakenly refer to a power of attorney for personal care as a living will. A power of attorney names a specific person to act on an individual's behalf. A living will, or advance directive, simply states treatment and personal care wishes and doesn't need to name anyone. However, these wishes can be included in a power of attorney document. Marriage and common law unions. Agents will encounter clients who are single, married, or in common law relationships, as well as those going through a relationship breakdown. In these situations, clients may have obligations for spousal and child support, so it is useful for agents to understand how these obligations can arise. It is crucial for agents to know that the property rights of married spouses are often significantly different from those of common law spouses when a relationship ends. The rights of married spouses to share in an intestate estate are also dramatically different from those of common law spouses. Marriage is a formal legal status acquired and terminated under federal law, though the celebration is controlled provincially. It has significant effects on property ownership and civil rights that are subject to provincial and territorial law. In Canada, any two people can get married, but an individual can only be formally married to one spouse at a time. Married status continues until the death of a spouse, an annulment, or a legal divorce. Couples can adjust their legal rights by entering into domestic or marriage contracts before, prenuptial, or during their relationship. Common law couples can also have a domestic contract, sometimes called a cohabitation agreement. In most provinces, common law status is determined by cohabitating in a marriage-like relationship for a specific period of time. Common law partners can acquire the right to seek spousal support upon a relationship breakdown. They may also be entitled to claim dependence relief if their partner dies without making adequate provision for them. Spousal status is also very important in pension law, as it can affect the right to be a surviving beneficiary. Agents can provide a valuable service by advising clients to seek legal advice on the effects of marriage versus common law relationships on their financial and legal arrangements. Divorce and separation. In the event of divorce or separation, the value of an insurance policy may be subject to property valuation and division. However, insurance proceeds received from a third party, similar to inheritances and gifts, may get preferential treatment and be excluded from the rebalancing of financial assets. Grounds for divorce and rights to spousal or child support are controlled by the Federal Divorce Act. Annulments, which treat a marriage as if it never happened, have the same main legal effect as a divorce. The marriage is dissolved, and the people are free to remarry. Since property rights are under provincial jurisdiction, most changes to financial status from a divorce, except for child support, arise from provincial and territorial laws. The effect of divorce or separation on insurance needs analysis and beneficiary designations is an increasingly important and complex part of insurance law. Family property. All provinces have laws that determine how spousal wealth and property are divided upon separation, divorce, or death. The division may depend on when and how the property was acquired. Family property generally refers to property acquired during the marriage, used by the family, or that generates income to support the family. This property is presumed to be subject to equal division when the marriage breaks down, at a judge's discretion. In contrast, property acquired before the marriage or from an inheritance is usually protected from division. The right to spousal support is separate from and in addition to the right of property division. These statutory rights can be modified if competent adults enter into a contract to do so. Wills, estates, and successions. Succession law is the body of provincial law dealing with deceased persons' estates and the rules for property passing as a result of death. An individual's collection of property and rights is called their estate. All provinces and territories allow an individual to prepare a will to leave their estate to whomever they wish. The person appointed to manage the estate is called the executor, executrix, or estate trustee. They have a legal obligation to pay the deceased's debts and taxes from the estate's assets and distribute the rest according to the will. Not all property is controlled by a will. Property held in joint tenancy usually passes outside the will to the surviving owners. Registered plans with a named beneficiary like RRSPs, RIFs, and TFSAs also pass directly to the beneficiary. Similarly, life insurance payable to a named beneficiary passes outside the will. However, if life insurance is payable to the policyholder's estate, it is disposed of under the terms of the will. Surviving spouses in pension law also have rights that take priority over designated beneficiaries and heirs, and these are also received outside the will or estate. Laws also protect those to whom the deceased owed legal or moral support. Financially dependent persons, such as a surviving spouse or children, can sue the estate for support if the deceased failed to provide adequately for them. These dependence relief laws give dependents priority over any distributions under the will. Even life insurance received as a named beneficiary may be considered part of the estate and subject to a court order for dependent support. Testate and intestate successions. Clients may die with or without a valid will. Dying with a will is called dying. Testate. Dying without a will is called dying. Intestate. If there is no will or no willing executor, someone must apply to the court to be appointed as the administrator or estate trustee. This is usually one of the adult beneficiaries. An estate trustee will distribute the estate according to provincial intestacy rules if there is no will. If there is a will, the executor distributes the estate according to its terms after debts are paid. Separation does not affect a will. A separation agreement may allow alimony claims against the other spouse's estate, but it usually doesn't affect gifts made by will or beneficiary designations. If a client wants to disinherit a former legal spouse, they need to change their will and beneficiary designations and sign a separation agreement. Divorce also does not revoke a will. But the will is interpreted as if the former spouse had died before the testator, revoking only the provisions referring to that spouse. Likewise, a divorce does not revoke designated beneficiaries, except in Quebec. A will made before marriage is automatically revoked upon marriage unless it was made in contemplation of the upcoming marriage and names the spouse. If beneficiary designations in a will are revoked and no other valid designation exists, the insurance or registered plan proceeds will be paid to the policyholder's estate upon death. If the policyholder dies without a will, the estate is distributed according to provincial intestacy laws. Agents should direct clients to legal advisors for estate planning or to manage life events like separation or divorce. Trusts and trustees. A trust established during the settler's life is an inter vivos trust. A trust established upon death is a testamentary trust. While guardians and powers of attorney have powers over a person's property, they do not take legal title to it. In contrast, a trustee has legal title to the property held in trust. A power of attorney may choose whether or not to act and can resign. A trustee, however, is under a positive legal obligation to act once a trust is created. A trust is a form of surrogate ownership where the trustee has title and control over the property, with the duty to distribute it to the beneficiaries. Example: Rob gives money to his lawyer to buy a house. The money is in the lawyer's trust account in his name, but it beneficially belongs to Rob. If the lawyer dies or goes bankrupt, the trust money is unaffected. Insurance proceeds can be used to create or add to a trust fund. Trustees can own any type of property, including an insurance policy, and can pay premiums from trust money. They can also transfer ownership of the policy or handle the proceeds according to the trust's terms. Agents should direct clients to legal advisors for trust and estate planning. Bankruptcy. Individuals who can't repay their debts are insolvent. If a creditor pushes for payment, a person may be declared bankrupt, leading to the appointment of a bankruptcy trustee. The trustee collects the bankrupt person's assets and uses them to pay creditors according to the rules in the Bankruptcy and Insolvency Act. Life insurance proceeds and financial products that qualify as life insurance, such as annuities and segregated funds, may have special protection against creditors. When an individual dies, the estate's representatives must first pay the deceased's debts and taxes. If there isn't enough money, the estate might be bankrupt. However, provincial insurance legislation states that insurance proceeds payable to beneficiaries do not form part of the insured's estate. Since they are not part of the estate, they are not subject to the estate's creditors. Additionally, when a beneficiary designation is in favor of a spouse, child, grandchild, or parent, the insurance money and the insured's rights in the contract are exempt from execution or seizure. This asset protection is why agents often advise clients to name direct beneficiaries instead of their estate. Irrevocable beneficiary designations also provide asset protection, as the policy itself is not subject to seizure or cancellation by creditors. Property divisible among creditors does not include any property that is exempt from execution or seizure under provincial law. For beneficiaries to be protected, there must be specific provincial legislation that clearly states that a particular insurance product is exempt from seizure. For example, in Ontario, the Insurance Act specifies that when an irrevocable beneficiary designation is made, the insurance money is not subject to the control of the insured's creditors. The extent of protection is limited by the terms of the provincial legislation. The use of irrevocable beneficiary designations is not common, and agents should advise clients to consult with legal advisors when needed. Pension funds, including LIRAs and LIFs, and annuities bought with pension money are also generally exempt from seizure. In some jurisdictions, registered products like RRSPs and RIFs are exempt from seizure even without a beneficiary designation. In all Canadian jurisdictions except Quebec, it is possible for the owner of certain registered products to name a beneficiary, which allows the death benefit to pass outside the estate and avoid probate fees. Legal principles for contract validity. A contract or agreement is enforceable under common law if it is created by parties who share the intention of entering a binding agreement. This meeting of the minds is essential to forming a contract. The contract's subject matter must also be acceptable under public policy, which refers to the principles on which social laws are based. For example, a contract to pay a criminal to commit arson would be unenforceable and void because it is against public policy. Civil fault. Civil fault is an action or omission that causes loss or harm to someone, for which the wrongdoer is liable. A breach of an agent's privacy obligations could lead to a civil action against the agent. Damages from civil fault can include injury to reputation, emotional or economic injury, violations of privacy, property, or constitutional rights, and neglect. A client who believes they are a victim of civil wrongdoing can initiate litigation against the agent or insurer. Limitation periods. Limitation period is a time frame within which a court action must be started, or the right to sue is lost. The clock starts ticking when someone discovers that civil wrongdoing has been done to them. Different jurisdictions have different limitation periods for various civil wrongs. Prompt legal advice is always recommended. Example: when an insurer refused to pay a death benefit because John had allegedly misrepresented his health, his beneficiary, Betty, had a limited time to file a lawsuit. Public insurance and retirement regimes. Federal and provincial governments have created programs that contribute to the social safety net. Agents must monitor changes to these programs to provide up-to-date information and understand how they might affect clients' needs analyses. When spouses are both entitled to benefits under a privately sponsored plan, care must be taken to avoid double payments. Coordination of benefits is a process where one plan pays first, and the second pays the remaining unpaid balance. This term also applies when coordinating benefits between a provincial health plan and a private insurer, where private coverage addresses services not covered by the public plan. Federally sponsored or facilitated programs. Federal programs include Canada Pension Plan, CPP, and Disability.Old Age Security, OAS, and Guaranteed Income Supplement, GIS. Employment Insurance, EI. The purpose of the CPP, OAS, and GIS is to provide a modest base for retirement income, not to meet all retirement needs. Agents should be able to guide clients with other insurance products, such as RRSPs and annuities, to help them achieve their retirement objectives. The EI program provides temporary income support to those who are between jobs, sick, on parental leave, or caring for a gravely ill family member. Agents can guide clients toward products like disability, AD&D, and long-term care insurance to supplement EI benefits if they are insufficient. Canada Pension Plan, CPP, and Disability. Individuals employed or self-employed in Canada must contribute to the mandatory CPP. Employers also contribute an equal amount for their employees. Contributions are tax-deductible for employers, and the pension is taxable income for employees when received. Individuals with high incomes do not contribute past the maximum pensionable earnings and must seek other forms of retirement security. A person can start drawing a reduced pension at age 60 or an enhanced pension at age 70. Contributors can also receive a disability benefit if they become permanently and totally disabled. The plan also provides a death benefit and survivor benefits for spouses and children. Old age security, OAS, and guaranteed income supplement, GIS. Unlike the CPP, OAS is a non-contributory, government-funded pension. OAS benefits are taxable income for the pensioner. The benefit amount depends on how long the resident has lived in Canada since age 18. The GIS is a non-taxable supplement for those already receiving the OAS pension. Employment insurance, EI. Individuals employed in Canada must contribute through payroll deductions to a plan that provides financial support during unemployment. EI provides temporary financial assistance to unemployed Canadians who lost their job through no fault of their own. Eligibility requires a minimum number of insurable hours, and benefits depend on the number of hours worked. Self-employed individuals are not eligible for EI benefits. Provincially or territorially sponsored programs. Provincial programs include no-fault automobile insurance. Workers' compensation. Universal healthcare and drug plans. These plans provide public coverage in specific circumstances and help avoid lawsuits. No-fault automobile insurance. This provincial plan reimburses a policyholder and their passengers without proof of fault, but restricts the right to sue other parties for losses. This public plan can be supplemented with private insurance products like disability, AD&D, and long-term care benefits. In provinces like British Columbia, Saskatchewan, Manitoba, and Quebec, the government provides basic insurance benefits, while private insurers sell top-up coverage. In other provinces, no-fault rules are incorporated into provincial law as regulations. Agents should be familiar with the regulations in their jurisdiction. Workers' compensation. This program provides no-fault compensation and rehabilitation benefits to workers. It is managed at a provincial level and funded by mandatory employer contributions. In exchange for these benefits, workers give up their right to sue their employers. Workers can supplement this with private coverage through disability, AD&D, and long-term care benefits. Universal healthcare and drug plan. Canadians with provincial healthcare enrollment can access universal healthcare anywhere in Canada through publicly funded doctors and hospitals. There are 13 separate plans coordinated under federal standards. Provincial and territorial governments also provide drug coverage benefits, paying for defined drug costs for specific groups like low-income individuals, the disabled, and seniors. Public plans can be supplemented with private coverage for disability, critical illness, and long-term care benefits. Other relevant legislation for life insurance agents. Agents must be continually aware of their obligations when dealing with life and health insurance contracts. Poor awareness can harm clients and lead to severe consequences for an agent, including monetary penalties and license revocation. Privacy Act. Life insurance agents have access to a great deal of personal information about clients, and how they handle that information is regulated by privacy legislation. The Federal Privacy Act governs how the federal government and its agencies handle personal information. Personal Information Protection and Electronic Documents Act, PIPEDA. More important for agents is PIPEDA, a federal privacy statute that sets rules for how businesses can collect, use, and disclose personal information during commercial activities. It also governs how federally regulated businesses handle employee information. If a province has similar laws, those laws take precedence. 3 provinces have passed privacy laws, and 3 others have legislation to protect personal health information. PIPEDA ensures that only necessary and relevant information is collected, and that it is disposed of carefully when no longer needed. Provincial privacy commissioners are also involved in these matters, especially with healthcare information. In other Canadian jurisdictions, PIPEDA applies. Human rights legislation. Provincial and federal human rights legislation prohibits discrimination based on personal and group attributes. This includes discrimination based on gender, religion, skin color, national origin, family status, marital status, sexual orientation, and age. However, insurers are permitted to discriminate in providing coverage as long as they can justify it on reasonable and bona fide grounds. Other relevant federal legislation. Agents should also consider the following federal laws. Criminal Code. This federal law defines crimes and serious offenses that can result in jail time or fines. Proceeds of Crime, Money Laundering, and Terrorist Financing Act, PCMLTFA. This law aims to detect and prevent individuals from using illegally obtained money in the financial system. Insurance agents are part of this process, as insurance products can be used for wealth transfer. Agents have a personal responsibility to report suspicious transactions and face severe penalties or imprisonment for failing to do so. Reports are made to the Financial Transactions and Reports Analysis Centre of Canada, FINTRAC. National Do Not Call List. DNCL. The CRTC created a system where clients can register their phone numbers to avoid telemarketing calls. These rules apply to agents who make telemarketing calls. They must register and subscribe to the DNCL, anti-spam legislation, CSL federal legislation that came into effect on July 1, 2014, prohibits sending commercial electronic messages, CEMs, without the recipient's consent. A CEM must have a mechanism to unsubscribe, and any request to do so must be honored within 10 business days. Agents should document their practices for handling client information from their first dealings. Genetic Non-Discrimination Act. The Supreme Court of Canada has confirmed the constitutional validity of this law. It prohibits anyone from forcing a person to undergo a genetic test as a prerequisite for providing goods or services or for entering a contract. The law also prohibits the communication of genetic test results for the same purposes.